Hello and welcome everyone. My name is Yasir Gulfraz and I'm your tutor for Law for Accounting, and I'm going to deliver learning outcome for today's, which is understanding areas of law affecting businesses and professional operations. Today we will be discussing the areas of law that affect business and professional operations, specifically focusing on data protection legislation, intellectual protection, and legislation relating to employment. By the end of this lecture, you will have a better understanding of these important legal aspects. So let's get started. Assessment criteria, then indicative content data, analyzing the requirements of data legislation. Data protection legislation is crucial for business as it governs the use of information in their operations in United Kingdom. So the primary legislation that addresses data protection in the Data Protection Act 2018, data DPA 2000, and the General Data Protection Regulations. The Data Protection Acts 2018 and General Data Protection GDPR, General Data Protection Regulations, outline various requirements that businesses must adhere to when collecting, processing, storing, and sharing personal data. These requirements includes obtaining consent from individuals, ensuring data security, and providing individuals with rights over their personal data. It is essential for businesses to understand and comply with these requirements, as non-compliance can lead to severe penalties such as hefty fines and damage to reputation. Therefore, business need to establish robust data protection policies and procedures to protect the personal data they handle. What is intellectual property? Intellectual property refers to creation of the mind, such as inventions, artistic works, brand names, and logos. Protecting intellectual property is crucial for businesses to safeguard their unique creation and maintain a competitive advantage in market. There are different types of intellectual property, including copyright, patents, and trademark. Copyright protects original works for authorship, such as books, music, and software. Patent safeguards inventions, while trademarks protect brand names, logos, and slogans. In the digital era, the protection of digital assets has become increasingly important. Businesses must take steps to safeguard their digital intellectual property, such as implementing cybersecurity measures and utilizing digital rights management techniques. Assessing the impact of legislation relating to employment. What is employment law? Employment law governs the relationship between employers and employees. Employment law covers various aspects, including the distinction between employed and non-employed status, the legal consequences of employment, key features of employment contracts, termination of employment contracts, unfair dismissal or wrongful dismissal, constructive dismissal, statutory redundancy, employer obligations regarding social security and equal opportunities legislation. By understanding employment law, businesses can effectively manage their workforce, establish clear employment contracts, handle termination procedures fairly, and ensure compliance with legal requirements. This helps to avoid legal disputes and maintain positive relationships with employees. Analyze the requirements of data protection legislations. So moving on, let's explore data protection legislation and its requirements. So data protection legislation is designed to safeguard individuals' personal information and ensure its proper handling. So we'll focus on the 6 principle of data protections, which you can see here. Consent of the data subject. We must obtain the individual's consent to collect and process their personal data. Then processing necessary for a contract. Processing personal data may be necessary to fulfill contractual obligations or take steps to enter into a contract. Compliance with the legal obligations. Processing personal data may be required to comply with legal obligations. Protecting vital interests. Personal data processing may be necessary to protect someone's life or well-being. Next is performance of a task in the public interest. Processing personal data may be carried out to perform tasks in the public interest or exercise official authority. Legitimate interests. Personal data can be processed for legitimate interests pursued by the data controller or a third party, except when these interests are overridden by the rights and freedom of the data subject. Also remember that it is crucial to understand and adhere to these principles to ensure the privacy and security of individuals' personal information. Any question if anyone is there? Okay. Personal data. So now we are going to talk about the important topics called personal data. Personal data is any information about a living individual which is capable of identifying that individual, that can identify them. So this includes thinking like their name, address, phone numbers, or even their online activities. It is essential to handle personal data carefully because it can reveal a lot about a person and should be protected. So now we also have something called sensitive personal data or special categories of personal data. This type of information includes details about a person, racial or ethnic origin, political opinions, religious beliefs, health condition, and more. Sensitive data requires even stricter protection due to its potentially sensitive nature. Any questions so far, if anyone is there? Okay, what is data protection? Anybody can tell me data protection? So we have laws like the Data Protection Act. This law outlines several principles that we must follow when collecting, using, or storing personal data. First, we should only collect information for specific purpose and avoid using it for any other reasons. This principle emphasizes the importance of transparency and consent. Next, we should collect only the data we need for a specific purpose. This principle promotes data minimization, which means we should avoid gathering unnecessary information. Keeping personal data accurate and up to date is another crucial principle. It is our responsibility to ensure that the data we hold is correct and reflects the current information about individuals. Safety and security also, here he's talking about safety and security are also vital aspect of data protection. We must take measures to keep personal data secure for unauthorized access or misuse. Encryption is one example of a security measures that helps protect data. So processing personal data should be done lawfully and individuals should have the right to access their data. This principle ensures that people can know what information is being processed about them and how it's being used. What is the GDPR, General Data Protections Regulations, which supersedes the Data Protection Act on 25th May 2018? The key May 2018, the key changes from the current law are strengthen rights or individuals and plan any obligations. Just hold for a minute, please, guys.
नहीं आप नहीं कोई मसला नहीं इंशाल्लाह मुलाकात हो चल गई है फिर अभी जा रहे हैं अभी हम जा रहे हैं अच्छा ठीक है आज तो बाद में निकल जाऊंगा नहीं इंशाल्लाह चल जाइएगा फिर इंशाल्लाह आपका बहुत शुक्रिया मैं रोटी लाया तो इवनिंग में जाएगा नॉट
Sorry, Mom. So, anybody can hear me? Okay, it is the General Data Protection Regulation which supersedes the Data Protection Act on 25th of May 2018. The key changes from the current law or a strengthen rights of individuals and place more obligations on organizations in looking after personal data. So in order to comply with the new law, you must have a legitimate reason for processing data. So legitimate reason, which can cover many of our usual processing activities, consent from individuals is also essential, and they should be able to provide or withdraw consent easily. GDPR emphasizes the concept of privacy by design and default. This means that when we start processing data, we should consider privacy aspects from the beginning and ensure that privacy settings are set to the most secure options. Subject access requests are an important part of GDPR. Individuals can request important information about how their data is processed and shared, not just what is held about them. Additionally, they have the right to request data deletion in certain circumstances, also known as the right to be forgotten. Also, GDPR also introduces mandatory breach reporting. In case of a data breach, organizations are required to report it promptly. Data processors, which are third parties who process data on behalf of others, can also be held liable for any mishandling of personal data. Any questions so far, if anyone is there? Okay. Next, we will go to page, if you come to the page 14. Yeah, page 14 is explain how intellectual property can be protected. So here we are going to talk about protect intellectual property law. Intellectual property or IP refers to creations of the mind, such as inventions, artistic work, and designs. It is important to protect your intellectual property because it allows you to earn recognition and financial benefit from what you invent or create. Types of protections. There are various forms of protection for intellectual property. Some types of protections are uh, uh, automatic, while other requires you to apply for them. So let's start with the automatic protections. Just quickly, we'll go through. Copyright is a form of automatic protection that applies to various types of creative work. When you create an original, literally dramatic, musical, or artistic work, you automatically receive copyright protections. So another one is data. Copyright also data design shapes of data design is shape of objects. Protection, you have apply of types of protections, examples of intellectual property and times to allow. Obviously, for trademarks, product names, logo, jingles, time to allow for application 4 months, registered designs, appearance of product, including shape, packing, patterns, colors, decorations. It takes 1 month for applications, and patent around 5 years. Inventions and product, for example, machines and machine parts, tools, medicines. Any questions so far, if anybody is there? Okay, how copyright protects your work? So copyrights protects your work and stops other from using it without your permission. You can copyright protection automatically. You get copyright protection automatically. So firstly, it is important to note that you receive copyright protections automatically. There is no need to apply or pay a fee for it, unlike some other forms of intellectual property such as patents or trademark. Copyright is inherent as soon as you create something original. So what exactly does copyright protect? Well, it covers a wide range of creative works. When you create something original in the field of literature, drama, music, art, illustration, photography, software, web content, database, sound and music recordings, film and television recordings. So broadcast or the layout of published work, you automatically gain copyright protections. So to let others know that your work is protected by copyright, you can use the copyright symbol along with your name and the year of creation. However, it is important to note that marking your work is not a requirement for copyright protection. Any questions so far? So how copyright protects your work? Any questions, if anyone? Okay. Copyright protections begins as soon as work is created. It means that when you create something original like a written piece, a song, painting, or a play, you automatically have the copyright for it. So this means that others cannot use or copy your work without your permissions. So in journal for written drama, dramatic, musical, and artistic works, copyright here copyright, how long copyright lasts. So copyright lasts for 70 years after the author's death. For sound and music recording, it lasts for 70 years from the first publications. For film, it lasts anyone is there? Okay, so for films, it lasts for 70 years after the death of the director, screenplay author, and composer. For broadcasts, it lasts for 50 years from the first broadcasts, and for the layout of published edition of written, dramatic, or musical works, it lasts for 25 years from the first publications. Patenting your inventions, here is talking about patents. A patent is a legal protection that allows inventors to have exclusive rights over their inventions. It means that if you have a patent, you can take legal action against anyone who makes, uses, sells, or imports your invention without your permission. What you cannot patent. There are certain things that you cannot patent. These includes literally dramatic, musical, or artistic works, ways of doing business, playing games, or thinking methods of medical treatment or diagnosis, discoveries, scientific theories, or mathematical methods. The way information is presented, some computer programs or mobile apps, and essentially biological processes like crossbreeding plants and plant or animal variants. Any question if anyone is there? Okay, protection of digital assets. Digital assets are intangible files that include things like digital photos, videos, and songs. It is important to protect these assets as intellectual property. To do so, we can implement measures like two-factor authentications or 2FA wherever possible to secure access to our digital files. We should also manage rights and access to ensure that only authorized individuals can use or modify our digital assets. It is crucial to follow Wi-Fi security best practices to prevent unauthorized access to our digital files. Additionally, obtaining the right insurance can provide an extra layer of protection for our digital assets. Any questions? Okay, next is remedies for unlawful use of intellectual property. Intellectual property refers to the legal rights granted to individuals or organizations for their creative and innovative works. It includes various forms such as patent, trademark, copyrights, and designs. You might wonder why it is crucial to protect intellectual property. Well, there are several reasons. Firstly, protecting intellectual property helps maintain the strength and uniqueness of your brand. If your brand is easily copied, it can lead to a dilution of its value and may result in losing customers. Secondly, protecting inventions through patents is essential for maintaining a competitive advantage. If others can easily replicate your inventions, it can undermine your profitability and market positions. To ensure the protection of intellectual property, it is important to conduct an intellectual property audit within your organization. This involves identifying where intellectual property is used, determining ownership rights, and assessing the value of the intellectual property assets. It is crucial to consider not only obvious forms of intellectual property, such as brands and logos, but also domain names, written materials, and other valuable assets. So, any questions so far? So, why should I protect my intellectual property? Some relevant questions. So, protecting your intellectual property is essential for the success of your business. Strong brands play a vital role in retaining loyal customers. If your brand can be easily copied, its strength diminishes, and you may lose valuable clients. Similarly, a valuable inventions set your business apart by solving problems in a unique way. If it can be easily replicated, other businesses can eliminate your competitive advantage. Carrying out an intellectual property audit, it is important to conduct an intellectual property audit. This audit help us identify where intellectual property is used within our organization. Here, patent importance of intellectual property for businesses. Patents are granted exclusively for inventions and provide legal protection for a specific period. Before pursuing a patent, it is important to conduct a patent search to ensure your invention is not already patent. Once your invention is patent, it becomes easier to take legal action against any third party they unfairly uses your intellectual property. Uh, Trademark, on the other hand, protect concepts and ideas associated with your businesses, such as slogans and brand names, while legal actions can be taken without registering a trademark. It is advisable to register it with the intellectual office, property office. Registering a trademark ensures a strong legal protection and demonstrates that the disputed assets has been used by you to build a solid trading reputation and goodwill. Importance of intellectual property for businesses. Uh, Copyright automatically grants protection to original literary or artistic creations, such as website contact, instruction manuals, painting around painting, sounds recording, and softwares. This protection is important for businesses as it safeguards their intellectual efforts, skills, and creative works for being copied to use without permission. So copyright protection encourages innovation and allows businesses to reap the rewards of their original creations. Uh, Assess the impact of legislation relating to employment. Employment law governs the relationship between employers and employees, outlining the rights and responsibilities of both parties. A future of outlining right and responsibilities of both parties as future professionals. It is crucial for us to understand the key aspects of employment law and how it affects the workplace. Employment law covers a wide range of areas. It includes legal requirements, checks, and processes involved in recruitment, ensuring their fair and non-discriminatory practices are followed. It also establishes the terms and conditions of employment, including matters such as data protection, holidays, working hours, and pay. Health and safety regulations are another essential aspects as they ensures that the well-being of employees in the workplace. Employment and the law. Here, understanding employment law is essential for businesses and employers alike. It ensures a fair and harmonious working environment, protect individuals' rights, and promotes compliance with legal obligations. Type of employments. There are two types of working relationship, employee and self-employed. So employees work under a contract of services and self-employed work under a contract for works under a contract for services, independent contractor. Employment Rights Act 1996, Employment Rights Act 1996. This act grants us as employees several important rights. These include the rights not to be unfairly dismissed, the right to redundancy payment if we are made redundant, and the right to a minimum notice period before terminating our employment contract. Equal Pay Act 1970. This act focuses not only on pay but also on other employment terms such as holiday and sick leaves. It establishes an equality clauses in all employment contracts, ensuring that if individuals of the opposite sex perform the same job or a job of equal value, they receive equal treatment. Any questions so far? Okay, working time regulations. We have working time regulations of 1998. These regulations restricts the number of hours we can work, setting an average limit of 48 hours per week. So also they grant us the right to 4 weeks of paid leave annually and at least 1 day off each week. Employment Act 2002, in which brought about several significant changes. It provides parents of children under 17 or disabled children under 18 with the right to request flexible working arrangements. Employers must seriously consider these requests and can only reject them if there are clear business reasons. Additionally, this act introduced paternity and adoptions leaves aiming to support families. National minimum wage. Ensuring fair wages, the National Minimum Wage Act of 1998 establishes minimum pay leaves of employees across the United Kingdom. So here are different wages for different age personals. This data is from April 2021, so current data is a bit different than this one. So statutory redundancy, if we have been working for our current employers for 2 years or more, we are typically entitled to this payment in the event of redundancy. The amount of statutory redundancy pay depends on our age and length of service, with different calculations for different age backgrounds. Termination of employment's contract. Dismissal generally refers to the situation where an employer ends the employment contract of an employee. So usually due to the fault of the employee, it is important to understand that dismissal occurs when the employer takes the initiative to terminate the contract. When it comes to notice period, it is crucial to know the minimum requirements set by the Employment Rights Act 1996. If a specific notice period is not agreed upon in the employment contract, this minimum notice period comes into effect. It ensures that employees receive a fair notice before their employment is terminated. Any questions, if anyone is there? Any questions so far? Or if you can't hear me or any issues, please do let me know if anyone is there. So we just talk about statutory redundancy pay, short-term temporary lays off. Short terms and temporary layoffs, it is possible to claim statutory redundancy pay if you meet the eligibility criteria and have been temporarily laid off without pay or with less than half a week pay. To be eligible, you must have experienced either more than 4 weeks of consecutive layoff or more than 6 non-consecutive weeks of layoff within a 13-week period. If you find yourself in this situation, it is important to inform your employer about your intention to claim statutory redundancy pay within 4 weeks of your last non-working a day during the 4 or 6 weeks periods. If your employer does not reject your claim within 7 days of receiving it, you should write to them again providing notice of your claim. Also, note that your claim for statutory redundancy pay may be rejected if your normal work is expected to resume within 4 weeks and continue for at least 13 weeks. Consultation. If you are facing redundancy, you are entitled to have a consultation with your employer. The consultation involves discussing the reason for the redundancy and exploring any alternatives to redundancy. Unfair, wrongful, and constructive dismissal. These are important concepts in employment law that relate to situation where an employer's job is terminated under certain circumstances. So to help us understand these concepts better, we will explore the guidance provided by the advisory conciliation and arbitration services in the United Kingdom. So any questions so far, if anyone is there? Okay. So the advisory conciliation and arbitration code of practices. Next is unfair dismissal. Your dismissal can be considered unfair if your employer fails to have a valid reason for letting you go and does not follow the proper disciplinary or dismissal process. This applies to both the internal procedures within your company and the statutory minimal dismissal procedure in Northern Ireland. So situations he's talking about, there are several situations where your dismissal is likely to be unfair. For example, if you're requested flexible working arrangements and were dismissal as a result, or if you refuse to give up your working time rights, such as taking rest breaks. Similarly, if you're resigned from your job and provided the correct notice period but were still dismissed, that could also be considered unfair. Other instances, including joining a trade union, participating in legal industrial action that lasted 12 weeks or less, taking time off for jury services, applying for maternity, paternity, or adoption leave, exercising your maternity, paternity, or adoption leaves, entitlements, asserting your right to receive working tax credit, exposing wrongdoing in the workplace, which is also called whistleblowing, or being forced to retire against your will, also known as compulsory retirement. Consecutive dismiss. This occurs when you are forced to leave your job against your will due to your employer's behavior. To be considered constructive dismissal, the reason for leave must be serious. For instance, if your employer fails to pay you or suddenly demotes you without a valid reasons, or if they impose unreasonable changes to your working conditions, such as requiring you to work night shifts when your contract only stipulates day work, Another example is if your employer allows another employees to harass or bully you. Equal opportunities legislations. What is the Equal Opportunity Acts 2010? These characteristics are crucial because they represent who we are as individuals, and they should never be a basis of unfair treatment. So let's throw them together. Firstly, we have age. This means that regardless of how young or old we are, we should all equal opportunities and be treated fairly. We have disability. It is important to understand that having a disability should never hinder someone from accessing the same rights and opportunities as others. Gender assignment is another protected characteristics. In the context of employment, marriage or civil partnership is also protected. This means individuals should not face discrimination based on the marital status. Pregnancy and maternity are important aspects of person's life, and they should not be barrier to their professional development or opportunities. Race is another protected characteristics. Also, religion is or belief is a fundamental part of our identities. And lastly, we have sex. Regardless of whether we identify as male or female, we should all have equal opportunities and be treated fairly. Here, ACAS Code of Practice: raise and deal with the issue promptly, act consistently, carry out any necessary investigations. ACAS Code of Practices. This code provides valuable guidance on how to handle various issues that may arise in the workplace. So first and foremost, it's crucial that we raise and address any issues promptly. This means that if you encounter a problem or have a concern, it is important to bring it up as soon as possible so that it can be dealt with effectively. Consistency is another essential principle highlighted in the ACAS code. We must act consistently when addressing workplace matters. This ensures fairness and avoids any perceptions of bias of discriminations. So when issues arise, it is necessary to carry out through investigations. This step involves collecting evidence and fully exploring the situations before making any decisions. It is important to gather all relevant facts to ensure fair and informed outcomes. So next is give individuals an opportunity to put their case before any decisions are made. So maybe accompanied at any formal meeting and right to appeal. So individuals have the right to appeal decisions made through the disciplinary process. If someone disagrees with the decisions or feels it is unfair, they can follow the proper channel to appeal and have their case reviewed again. Here, disciplinary establish facts, investigatory meeting. So then investigate fully and collect evidence. Then no disciplinary action at the investigation meeting. So next is suspension must be paid, and then short time as possible. Disciplinary inform ideally 3 days written notice, give full details including copies of evidence, say if dismissal is possible, and right to be accompanied. So once the basically investigation is complete, the individual must be informed in writing about the disciplinary process. Ideally, at least 3 days written notice should be given along with full details of the allegations including copies of any evidences. It is important to clearly state if dismissal is possibility, ensuring transparency throughout the process. Right to be accompanied, a fellow worker, union rep, minute takers. So individuals have the right to be accompanied by a fellow worker, union representative, or a minute taker. This ensures that they have the necessary supports and representations during these important discussions, meetings, or during the case. So meetings, review your evidence, prepare questions in evidence in a confidential room, no interruptions, remind of right to be accompanied, stay calm. Any questions so far, if anyone is there? Okay, in preparation for the meeting, it is important to review all the evidence and prepare a question in advance. The meeting should take place in confidential room, free from interruptions. It is important to remind the individuals of their right to be accompanied and to maintain a calm and respectful atmosphere during the meeting. If needed, the meeting can be adjourned to allow for further consideration before making a final decisions. Decision making, disciplinary, secret recording, reasonable sanction, state the reason and the improvement expected, set a time for review, remain current for limited times. So when making decisions within the disciplinary process, it is important to consider any evidence presented and the overall circumstances. Secret recordings should not be used as evidence. The decision should be based on whether disciplinary action is warranted, and if so, what are reasonable sanctions would be. The decision must be confirmed in writing, clearly stating the reason for the decisions and any expected improvements. Also, it is important to choose wording carefully and set a specific time for review. If the individual fails to improve, the decisions remain in effect for a limited time and they have the right to appeal. Gross misconduct, immediate dismissal for a first offense, follow a fair disciplinary process, and no notice pay will be due. Gross misconduct. In cases of gross misconduct, immediate dismissal for a first offense may be justified. However, even in such situation, it is essential to follow a fair disciplinary process to ensure that the action taken is reasonable and justifiable. In cases of gross misconduct, no notice or notice pay will be due. Any questions? If anybody can see me, or if anyone is there, any questions so far? Appeal process. So individuals have the right to appeal any disciplinary actions that has been taken. It is important to insist that appeals are made in writing within a specified time frame. The appeals process should mirror the disciplinary process, and the appeal should be reviewed by a manager who has not previously been involved in the case. The outcomes of the appeal should be communicated as soon as possible, and typically there is no further right of appeal after this stage. So here can appeal against any disciplinary action, insist appeal are made in writing by a set time, mirrors disciplinary process. Managers and previously been involved inform the outcomes as soon as possible, no further right to appeal. So grievances. Establish the facts, notice of formal hearing, right to be accompanied decisions after the meeting, inform them accordingly, right to appeal. Here we are briefly will touch upon grievances. When handling grievances, it is important to establish the fact through a formal hearing, giving the individual the right to be accompanied. A decision should be made after the meeting and the individual should be informed accordingly. Just like with disciplinary matters, individuals have the right to appeal decisions related to grievances. Recommended actions: follow the ACAS for all disciplinary and grievances, suspend with pay while investigation, gross misconduct, they can't dismiss you straight away. So if you are unhappy with performance, act early. Dignity and responsibility: keep dignity front of mind, take responsibility for ensuring dignity. Also clarity: ensure you have been understood and ensure that you understand. So here, fairness in recruitment selection. HR planner has to consider a number of equity issues in recruitment and selection. Employers unlawful discriminations, which include sex, including pregnancy, maternity, marital status, gender assignment, sexual orientations, race, national origins, ethnic origins, religion, disability, religion or belief, lack of any religion or belief, age, trade union membership or non-membership. Basis of discrimination: direct discrimination, treating somebody less favorably on the grounds of the sex, race, and so on. Indirect discrimination refers as applying an apparently general rule which in practice disadvantages one sex or race. Harassment violation: someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And victimization: treating someone unfairly because of, for example, the plan to raise a discrimination related grievances. Here, fairness and protection during employment has a number of rights throughout their terms of employment, which you need to be aware of. Here's list with the resources you need to use to find out more. So it is unlawful to discriminate on the ground listed in the previous part in the areas of promotion, transfer, training, and development. Under the Health and Safety at Work Act 1974, the employer has a duty of care towards employees and anyone else who may be affected by their business and its activities. Then under the Data Protection Act 1998, the employment must comply with 8 principles to protect personal information. Information must be fairly and lawfully processed for limited purposes, adequate, relevant, and not excessive, accurate, and up to date. Not keep for longer than is necessary, processed in line with your rights, secure, and not transferred to other countries without adequate protections. Under the Information of Consultation of Employee Regulations 2004, employers with 50 or more employees must provide written statement which specify the main terms and conditions of employment, itemized pay statements, health and safety information, and information about the businesses, economic situations, employment prospectus. So they must also consult with employees about occupational pensions, health, safety, planned collective redundancies, and transfers of business ownership. Family friendly law falls under a number of headings: maternity rights, adoption rights, parental rights, paternity leaves and pay, rights to request flexible. Then maternity rights is talking about child has a number of rights provided by legislations, protections from discriminations on the ground of pregnancy, the right to statutory maternity leaves by 52 weeks, and right of statutory maternity pay SMP for up to 39 weeks. Then adoption rights, then any adopting a child has the following entitles: protections from discrimination on the ground of adoptions, right of statutory adoption leaves for 52 weeks, and right of statutory adoptions pay for up to 39 weeks. Parental leave have been employed by the same company for a year or more, or employed with a contract employment, or a parent named on the child's birth certificates are named on the child adoption certificate, or have legal parental responsibility for a child under 5. So next, foster parents have following adoption leave rights. The employee can take a total up to 13 weeks parental leave for each of their children up until their 15th birthday. If the child is adopted, they can take a total of up to 13 weeks parental leave until the 5th anniversary of their placement, or until their 18th birthday, whichever comes first. Paternity leave and pay. A male employer can take statutory paternity leave of up to 2 weeks if they are employed with a contract of employees are the biological father of the child, or the mother's husband or partner, including same-sex relationship, or are the child adopted or partner of the adopter, have been with their employer for at least 26 weeks by the end of the 15th weeks before the start of the week when the baby is due, will be fully involved in the child upbringing and are taking the time off to support the mother or care of the baby. Leaving the organization, employee may leave employment of their own accord or be dismissed with or without notice, which means the contract of employment is terminated. Unfair dismissal is when the employee is dismissed and the employer doesn't have a valid reason for the dismissal or has acted unreasonably. So fair and unfair reasons of dismissal: misconduct, capability, redundancy, retirement, legal restrictions, legal reasons that prevent you from doing your job. For example, where an employee is banned from driving, but driving is an essential part of their job. Some other substantial reasons, other reasons other than the 5 above. So that's all for today. So if anyone there, if you have any question, please, you can ask. That's all for today. Or we will discuss our assignment on next weekend. So by then, if you have any question, please drop me an email at yasir@ukversity.com, ukversity.co.uk. And have a good evening, guys, if anyone is there, and see you next Saturday. Bye for now.